Any mentioning?
Mention my lord CS 157 of 2020
Not in the list today.
for inclusion of the matter. Appearing in the warning list. My
It will come.
Gorgeous side listed matters. Item number 1.
lord, I am appearing for the plaintiff, my lord. My lord, I am seeking an adjournment, my lord. Kindly keeps it, my lord, after vacation, my lord.
You are plaintiff.
Yes.
On prayer of the plaintiff, the suit is adjourned to 18 June.
Okay.
This is part heard, but I can release it also.
Kindly, my lord, kindly extend the time for compliance, my lord. That
Compliance of what?
compliance of my lord commercial suit compliance.
Well, in this suit, my lord, has been transferred from the ordinary jurisdiction to the commercial division.
I should release it.
No. Kindly retain it, my lord. My lord has
Decree was passed.
no decree has been passed. My lord is hearing it. And then in the midst of that, my lord, the suit was been transferred. Only my lord will adjourn the matter and extend the time for my compliances, my lord.
Compliance with the order dated 19 February 2025 shall be done in the meantime.
Great. 19 February. Great.
Item number 3.
Some corrections are to be made.
Yes.
That will be done.
Great. My lord, may I also point out, I don't know if I had already pointed it out during the decree settlement on page 2, my lord. The name of my client appears as Miss Prakriti.
Yes, those corrections are to be made.
Grateful, madam.
ठीक है. Item number 4.
Please, your lordship. My lord, in this matter, my lord.
What is J5?
I'm sorry, 4 is up.
In the goods of Krishna Majumdar.
GA9. Mistake क्यों था? 5 posted lordship.
Correction दिखे कोई दियो ना order. Item number 4.
Krishna Majumdar, my lord. Let's GA9 perhaps, my lord.
GA9, yes.
Yes. GA9, my lord, was my application, my lord, for reimbursement of certain expenses which had been incurred by me when I was administering the estate. The lordship had been pleased to, my lord, direct the learned administrator Pendant Light to file a report as to how much should be made due and payable to me. She has filed, my lord, 2 reports, and my lord, she has come to the conclusion that a sum of rupees 3,51,425 and 50 paisa can be disbursed to me. My claim was, my lord, for a much higher amount, my lord. Today, my lord, I will only trouble your lordship, my lord, to the extent, my lord, I am praying, my lord, for a direction upon the learned administrator Pendant Light to release this sum to me by giving me a check, my lord. She has the control of the bank accounts, everything. And my lord, so far as the other...
Stated.
My lord, she has filed a...
Give her not, give her not.
This is, my lord, a report dated 11th March 2025.
2 reports are there.
No.
In this
Sorry, 28th March.
Matter, my lord, I am appearing on behalf of all the defendants, your lordship.
She has not summed up the amount.
No, so she filed a sum. You're right. Therefore, your lordship had been pleased to pass an order asking her to sum up the amount by an order dated 11th March, where she did sum up the amount finally. And that is another report, my lord, dated 28th March, 2-page report, my lord.
20th March.
28th, my lord. Was perhaps filed on the...
One on 30th January 2025.
Yes.
The other is on...
The other report is on 28th of March, your lordship.
No, 10th February 25.
My lord, I can hand over a copy just to expedite it.
It's there.
But I've handed over a copy.
Why should, with the original? The original should be here.
Should be.
Why should I look into the copy?
My lord.
Oh, no.
This is example of piecemeal works that creates confusion.
I know.
Do one thing, come on Monday.
My
Take
lord,
the record in the meantime,
my lord.
not this week.
Grateful to you.
Well, so far as the main suit is concerned, my lord, my learned friend's witness was being examined on the last occasion a few days back. My lord, my learned friend had submitted that he has filed an
Yes, your
application
lordship.
for my lord bringing on certain further documents.
Yes,
My
your
lord, I've
lordship.
checked the website, my lord. No
No, your
such
lordship.
application has been filed, subject to correction.
No. We have just filed it, but it's lying with the master, your lordship.
What is the next date?
No next date has been given
It
because your
is-
lordship
it's
was
your
pleased to
lordship.
indicate that this application should be heard first.
Yes, your lordship.
But no application has been filed.
No, your lordship. We have
It's
filed.
lying with the master.
Yes, your lordship.
Unless master signs, it is served, it will not be filed and given an order.
So it's not been filed. Master summons is going to apply.
So we have to fix the date.
Yes, your lordship.
Come on Monday.
Lordship.
Grateful.
Monday or Tuesday, whichever will be convenient.
I'm grateful.
By whichever.
And try to find out this report.
Yes, it's just a small report. I'll be look at the records during the.
Otherwise, this
Great.
administrative penalty is to be called in a court.
Yes, otherwise. Oh, she's here.
Check it. I'm not able to file the reports because you set out a table. What is the sum of the table? That should be summed up. Where is that? Find it out. I am not able to find that. Check it. Where have you stated? Come on Monday. Find it out. Come on Monday.
8th April. 8th April.
But that should be on the record.
Yes,
Yeah.
your lordship.
Because she has given both parties
Yes,
copies.
your lordship.
So that's
Filed at March. 20 March. They signed on 20 March.
Signed on 20. Yes.
But that should be on record.
Yes, lordship, filed.
You might have missed it.
And then in fact, your lordship's order of 8th April also records the fact that she has filed it on 8th April. Report dated 20th March 2025, filed by the learned administrator pendant light may be kept in record. So it was
সেটা
filed.
খুঁজে বার করো কোথায়? Come on Monday.
Lordship. Lordship. I'm grateful to you. Lordship.
Check in the meantime.
আমার কপি দেবে
No, let me find it out. Because my order says it was filed. So it is to be traced.
Otherwise, my learned friend can carry another original perhaps in case.
If it is not found, then she'll do.
Yes. Great.
She can keep one thing ready. You can
Yes,
keep one thing ready. One another. original ready.
In the event it is not. Grateful.
Item number 5. Vijay will give.
Item number 5, I appear for the defendant in the matter. My lord, we have filed an application GA6.
Hmm.
That's a Order 7 Rule 11 application. My lord, by order dated 20th January 2025, my lord had given the time to the plaintiff to file their opposition to it. Time of 2 weeks was granted. My lord, they haven't filed their opposition in this application yet.
My lord, I am instructed, I have been briefed today morning, I am instructed that there was a loss of contact with the client, my lord. But now the contact has been re-established, client is giving instructions again, my lord. I have been instructed to pray for 2 weeks time, my lord. These are my instructions, my lord. My lord, kindly consider and passes an order. Pray for 2 weeks time, my lord, we will file the
Time is
opposition.
extended to file affidavit in opposition by 2 weeks. Affidavit in reply will be filed within 1 week thereafter. The matter will appear in the list on 12th June. Why have filed this Order 7 Rule 11? What are the grounds?
My lord, this suit was filed. It is not in compliance with the commercial division.
Let me see the plaint.
On the last occasion, my lord, I mean, led by Mr. Shumavo Ghosh. On the last occasion, my lord had asked about
It will
the.
be simply transferred. You may file it, but it will be transferred. Not be rejected. Plaint will not be rejected. Anyway.
Item number 6. Broadway Center.
Your Lordship, I'm appearing for the plaintiff in this matter.
My lord, I am led by Miss Sengupta. Is online. She is
I
online.
can't hear her.
For amendment of existence, madam, if an application has been filed by them and there was a delay to file the affidavit. But due to my surgery of my grandmother, put a dash on that.
Affidavit in reply could not be filed. Affidavit in reply.
Lordship, am I audible, Your Lordship?
Yes, to a certain extent. She is seeking for an accommodation, for fortnight accommodation to file affidavit.
Yes.
I am allowing it.
Your Lordship, the last direction was on 28th January 2025 to file the reply, my lord, by February.
No further time.
Kindly makes it peremptory.
Another accommodation is sought for by the learned counsel for the defendant to file affidavit in reply. Full stop. Adjournment is given peremptorily. The matter will appear in the list on 11th June. Affidavit in reply shall be filed in the meantime. In default, it will be deemed no affidavit in reply is to be filed.
My lord, if your lordship, my lord, kindly pass an order for service before the date of.
Affidavit in reply shall be served prior to the adversary, prior to filing in this court to the adversary.
Grateful, Your Lordship.
Item number 7. Item 7, Vinod Kumar Dubey.
For defendant number 3, my lord.
Who is the plaintiff?
The last occasion, my lord directed the plaintiff to file the report so as to what was the fate of the
Last order to dekhiye.
fate of the mediation, my lord.
None appears for the plaintiff. The learned counsel for the defendant number 3. 3 is present. You are for?
9.
Defendant number 3, defendant number 9 are present.
But interim order may be extended, my lord. My GN19 is my application for receiver's application, my lord.
If the plaintiff doesn't appear, suit will be dismissed simply. Let the suit appear in the list on 16th May.
Item number 8.
Interim order is very good.
Interim order is extended till the returnable date.
Grateful.
8.
I pay for respondent number 1 and 2 in this matter.
Mrs. Chakraborty is supposed to appear. You are for?
For the respondent number 1 and 2.
A scheme was framed and I was hearing the matter whether uh, proposed
Yes, Your Lordship.
proposed removal should be approved or not.
Yes, Your Lordship.
What was the last order?
Lordship, the GA 17 was disposed of. The petitioner had prayed for removal of the other Shebites as per the will.
Some directions were given.
Yes, Your Lordship. 17 was
Accounts.
There was a
Direction to file accounts.
the accounts of expenses from 2005 till date.
Learned counsel for applicant seeks for accommodation. Let the matter appear in the list. You are filing accounts. Line ta kete dao.
Lordship, a copy may be served upon us.
Who has signed this? One advocate has signed this. Shebites are supposed to sign this. Take it back, get it signed by Shebites. Time is extended to file signed audited accounts, signed accounts in terms of order dated 7th April 2025. The account statement of account shall be signed by the responsible Shebites. The matter will appear in the list on 13 June.
Nine and 10.
My lord will hear 10 first because my lord was hearing 10 first. Result of 10 will be determined. My learned friend is concluded. I was good to address my lord. Given my notes. My lord, he has got two notes. Yeah, are you pressing both notes because they're contradictory?
One was my lord, a brief note of facts. Yeah. Second one was more comprehensive. It contained all the judgments with relevant paragraphs also.
Which should I look into?
The second one, of course.
That means I take it as the first one. I'm ignoring the first.
So do one thing. First one may take back the first one. The issue of facts are there in the second note.
Second note has everything. Facts and law, the judgments.
All right. So take back the first note. I'll pass order.
Right.
Otherwise, that will create confusion.
Yes. Basic stand which my learned friend takes is that according to him, there has been a merger of two decrees. I am trying to enforce the first decree, and therefore the application is not in correct form. But I would first appreciate this is not an execution application at all. In a pending suit, I filed an application to bring on record certain events that have happened and certain acts of the receiver. But he relies upon to show, he relies upon 3 paragraphs basically and says, see, I'm trying to execute the first order. My lord, there was a decree. The decree said, restrain the defendant from transferring, alienating, dealing with the property, etc. for a period of 25 years. After that, an appeal was filed. But during the pendency of the appeal, and while admittedly there was the first one remained in force, all these acts were done. What he did was act in violation of the first one. In any case, my lord, there was no question of merger because there was no issue which was decided by the trial court, which was decided contrary. The appeal could, my lord, just to give my lord a little bit of background, 5 suits were disposed of by passing.
Where is the order of the division bench?
My lord, the division bench order will start at page 174.
Second volume.
But my lord, before that, the 5 suits were disposed of by allowing one application for preemption. It is recorded in the appeal court order itself that I do not challenge it. The mistake that was made was not really a mistake on any of the issues. While allowing the application for preemption, the learned judge, by inadvertence, forgot to say that what would happen if payment was not made. He said, okay, you're going to buy the property at a price to be fixed by the register of assurances. And I'm on that same day, I'm going to sign the conveyance. But, and he said that if I do not sign, the registrar will sign on my behalf. However, the decree did not provide that in the event you did not pay, then what would happen? That is all that the appeal court has done in that. Clarified that yes, and the appeal court specifically records that the preemption is not challenged. My lord, it starts at page 174.
187, page 187. The page 187.
That, my lord, look at the number on the right.
Yes. Written by pen. 169, 187.
169, 187. My lord, it says the court has the power to make more than one preliminary decree. It's power to, my lord, there's a specific finding. It says that
on the date of making application so and so,
yes,
the valuation of the property was 944 so and
yes,
so.
that he was asked to pay, but it specifically records that it is that the preemption is not being challenged.
And then C, come next page C, if there is default on the part of Shankar.
Yes, my lord. That is the only thing that has been added. And he also adds, my lord, Shankar had been directed to remain in possession, not transfer alienate. That has been continued by the appeal court. My lord, C is at page 170 or 188, internal page 15. B, Shankar will continue to remain in possession of the property until further orders. There was no change. And the learned judge specifically, the learned division bench specifically says, retains the first preliminary decree passed by the lower court. My lord, see the last paragraph on that page. At page, internal page 15. The impugned judgment in decree is modified to the extent above, treating it as the first preliminary decree. He retains it. And he says that my decree will be another preliminary decree. If he does not, and if he does not pay within this time, the trial court will pass a third preliminary decree. That application is also there pending. And my lord will see what I have done. I have not asked for any execution of any particular order. I brought all these facts to the notice of the court. My lord, see, my lord, he is objecting. He says, my lord will take my petition, which is annexed to this. My lord will take my petition. He draws my lord's attention to paragraph 20 of my petition.
In such circumstances, there is no violation. You say page 13.
He relied upon paragraph 20, 3 paragraphs of my petition. Paragraph 20, 28 and 32.
20?
28 and 32. My petition starts.
Your petition is GA17.
It has been annexed here. No, this is GA15. This is, my lord is hearing GA17 now, which is their application.
GA15, you said.
My lord will not look at those papers. My lord will kindly look at GA17 itself. This application is, otherwise there will be confusion. My lord is annexed. My lord, see, 15 to show you, 15. My lord will take GA15 and annexed to GA17. My lord, this starts at page 17. 90% of GA17 is the annexure of GA15.
Starts from 17.
My lord. And my lord will.
This is basically GA15, you said.
This is GA15.
15 of 24.
This is GA 15 of 24, I presume. No, may not be.
21.
21. 21. These are my pleadings when I come. Now let's see the paragraph 20. He said the plaintiff, upon causing searches to be made in the records. Now let me remember 4 days, very important. The decree was passed in 2014.
Preliminary decree.
He termed it as the final decree. He didn't say preliminary or final, but since he had not provided a clause which said what would happen if he did not pay, there was nothing left in the suit because there was no partition to take place because preemption was allowed. But if he did not pay, then of course the preemption application would fail and the preliminary decree would have to be passed.
Another preliminary decree
would have to be passed.
So there is a decree or judgment, whatever we may say, passed by Justice Basak.
That's what Basak on 12th September 2014. Very important. I want to remember that. The appeal court comes in December 2020 or sometime in 2020. My lord, he relies upon, for this argument about merger, he relies upon 3 paragraphs. First is paragraph 20. My lord, we'll see what I've stated in paragraph 20. The plaintiff, upon causing searches to be, my lord has got it, internal page 17. Plaintiff, upon causing searches to be made in the records of the additional register of assurances, Kolkata, has come to learn that Shankar Prasad Garga, being the receiver defendant number 2, above named one of the owners of an undivided share in the premises number such and such, in breach of the restraint imposed upon him by the aforesaid judgment dated such and such, whereby the defendant Shankar had been restrained from selling, alienating, encumbering, disposing, or parting in possession, or transferring his share in the respect of premises whatsoever, for a period of 20 years from the date of judgment, executed a deed of gift purporting to make over. So, my lord, at this point, my lord will see the date in 2017. This couldn't have been in violation of any other order because that was the one which was enforced at that point of time. The appeal court order came much later. So, this is what I've stated. Then, my lord, he says, paragraph 28. Talks about all these. The plaintiff submits that in each of the aforesaid documents, namely the deed of gift dated 28th March 2017, executed by defendant number 1 in favor of Soria and registered at such and such, the deed of declaration for common passage executed by defendant on 27th October 2017 in favor of the KMC registered at such and such, being number such and such, the agreement for development dated 6 September 2017, such and such. My lord, we are talking about all these documents. And we are saying that they have been brought about at page 25, after listing all the documents, page internal 24, they have been brought about being in flagrant violation of the aforesaid order of injunction passed by the Lordship Honorable Justice Devanshu Bashar. At that point of time, the division bench judgment had not yet come. Now, my lord, the main thing is page 32, this is the next paragraph, which is actually the main paragraph. Paragraph 32 at page...
Paragraph 32.
Yes, my lord, internal page 28. Shankar Prasad Garga, the defendant number 2, having been appointed as the receiver of the said premises, was under a duty not to change the nature and character of the premises and not to induct tenants and occupiers of the said premises, causing embarrassment thereto. The Honorable Court had, by the aforesaid judgment and order dated 12th September, also restrained Shankar Prasad from selling, alienating, encumbering, disposing, or parting with possession, or transferring his share in respect to the suit premises in any manner whatsoever.
That is sum and substance of your case. The said party receiver.
28. Then he said, the Honorable Appeal Court had also, by its aforesaid order dated...
No, your sum and substance of your case is said party receiver and his purported successor in interest are entering into transactions in like so and so.
Yes. Being in violation of not only the order passed by Justice Bashak, but also the Honorable Appeal Court's order. It says the Honorable Appeal Court, by its aforesaid order dated 14th February 2020, directed that Shankar will continue to...
This is your case.
Possession of the property until further order.
This is your case.
This is always my case. So there was no question of any merger. I've said he injuncted, after that appeal court also did it. And see my praise on this basis.
And any meanwhile transfer is void.
All the meanwhile the transfer is void. And therefore, see what I've prayed for. I've prayed for cancellation of all these documents. And I've asked for the receiver to take physical possession and to hold it. Why? Because Shankar, if he has transferred or if Chaudhary had transferred, that was in violation of not only Justice Boshak's order, but also the appeal division bench order, which also directed Shankar will continue to remain in possession. This is not an execution application that I've said, I'm executing this decree. You are saying, no, this decree has merged with that decree. This is not that at all. This is an application bringing on record the facts, bringing on record both the judgment of the trial court, the judgment of the division bench, and showing the conduct of the defendant number 2, who was also the receiver, and asking to set right all these acts of the defendant number 2 receiver.
All right, I've heard you.
And this is only on the ground of merger. So merger really doesn't apply at all. And in any case, the division bench preserved the.
So according to you, even if there is merger, only to a very small extent.
Yes, even if there was merger,
Same order is there.
Same order was continued by the division
with
bench.
little modification.
Yes, and the division bench said that it is only modified to the extent above. That means the rest remains. And not only that, division bench also said,
by nature, some additions were given.
Yes, and he said also and made it clear where he said that Shankar will continue to remain in possession of the property until further orders. This was also not only the division bench, the single bench had already said so, but the division bench also clarified and directed that Shankar will remain in possession of the property until further orders. That means he is not going to alienate or transfer. Now, my lord, what is their case? Remember, he was not a party to the suit. He was nobody. He now comes up and says, I am a tenant who has been inducted by Shankar. Firstly, it couldn't have been done. Shankar had got no right to alienate.
There was a restraining order.
Exactly. At that point of time, the appeal was restrained.
Restraining order in respect of possession also.
Everything.
Neither transfer of title nor transfer of possession.
Possession, alienate, part with possession, everything. Most omnibus. Admittedly, that order passed by Justice Boshak was in force at that point of time. Even he doesn't say it was not. My lord, see what he says. He relies upon a tenancy agreement. My lord will find it at page 359. I think that's in volume 3.
Yes. That was shown earlier.
He must have shown it. My lord will see there's an agreement dated 30th January 2015.
After passing of the order.
After passing of
single bench order.
Single bench order. Admittedly, the single bench order
So
would be
this very agreement, the execution of the agreement hit the order.
Exactly. Admittedly, even if there was merger or no merger, the single bench order remained in force till the division bench came in. And division bench only extended it.
Was there any stay? Was there?
Absolutely not. Well, we'll see 30th January 2015.
Yes.
Now, what is being done? Between Shankar Prasad Garga, son of Shankar, that is the receiver.
It will start from January 2015.
Yes, sir. And it says, whereas the first party is the landlord in respect of premises number 78 Rafi Ahmed Kidwai Road. Firstly, he is not the landlord. He is only a minority shareholder. I am the majority shareholder. Admittedly, as per the board degrees. But whatever it is, he says that I am the landlord. And my lord, see, the first party, I am reading the bottom of page 2. The first party has agreed to let out and the second party has agreed to take. All that a flat measuring about 1500 square feet, be the same, a little more or less with attached bathrooms, etc. at a rental of rupees 200. Very important, 200. My lord will see. It is to be used only for commercial purpose and not residential. My lord will get it at the bottom of page 361.
Yes, I've seen that.
He says, my lord, page 362, very important. Paragraph clause 9. If at any point of time the second party intends to terminate or surrender his tenancy in respect of the schedule mentioned flat, then he should offer the first party. And if the first party will be able to take tenant possession of his tenanted portion within 2 months by paying the market value of the consideration money of the possessive right in respect to his tenanted portion, then the second party will be under an obligation to surrender his tenancy right unto and to the first party. And if the first party is failing with, the second party will be liberated to transfer right to any third party. That means he'd taken a huge amount of salami and given it to him and said that you tenant, if you want to transfer it to anybody else, you first have to offer it back to me. If I agree to buy it back, otherwise you can give it to a third party. It was basically a sale because he has to pay the market value to get it back.
Yes, I've seen.
And
2
admittedly,
months by paying market value of the consideration.
admittedly, he also says that I think he said that he had paid a sum of rupees, 6 lakhs. It is, and he stated a figure.
Some amount of money was paid.
And he has said specifically that he has made payment. Kindly give me a minute. Just give. My lord will take the petition itself, page 12.
There is GA17.
GA17. We only looking at GA17.
Page?
Page 12. Paragraph 15. The applicant states that the applicant would put in possession of a part of the premises in lot 2 of the said premises in around 2015. It is pertinent to state defendant Shankar Prasad Garga and his son has lawfully inducted the applicant in the said premises with the knowledge of the then plaintiff and has put the applicant in possession of lot 2, a flat measuring such and such, and with 2-3 car parking spaces. Subsequent thereto, the defendant being the owner, executed agreement for tenancy in favor of the applicant on receipt of valuable consideration. It is not a tenancy, yes, on receipt of valuable consideration. The applicant had made payment of rent, such rent and receipts to the effect, and when Shankar Prasad received, my lord will see, 17. Shankar Prasad Garga had received a substantial amount for putting the applicant in possession thereof. Paragraph 18. Such tenancy was a monthly tenancy commencing on and from January 2, 2015. Additionally, it was promised by the defendant that 90% of the sale proceeds of such premises in respect of which the applicant is a tenant, if sold on a future date, would be paid to the applicant. He would get 90% of the sale because he has paid now. My lord, now see what is the effect of this. My lord will come back to their application. It's the tenancy agreement itself at page 362. My lord will. My lord, see, the agreement is supposed to be with Shankar. Now, who has signed it?
Shankar signed it.
No, he doesn't.
But name of Shankar Prasad Garg.
On top of the agreement. But who signed it? Not Shankar. For Shankar. Shakti signs it. His son. Sorry, not Shankar. Surya signs it. His son. For Shankar Prasad Garga, Surya Prasad Garga. So-called signature of Shankar is supposed to be there as a witness on the left. My lord, see the next page. He gives the Shakti gives the Shoda gives the undertaking that I am not going to make any construction here.
It was done. It was done. Construction was made.
Construction after the building has come down. My lord will see the annexure after that. My lord turns the page. My lord, remember the rent was 200 rupees. All these rent sheets have been manufactured. My lord will kindly Kindly take the first receipt. January to
1200.
1200. See the next page.
1200.
January to July. In the hurry to manufacture, January to, there's 7 months. It cannot be 1200. Now, my lord, what is the effect of this agreement? My lord will kindly take the premises tenancy act. I will kindly take section 14. This whole agreement is void. Firstly, it is in violation of the order of court.
Premium.
Otherwise,
Premium. Receiving premium.
receiving premium and also agreeing to pay premium at handing over. Restriction. No person shall, in consideration of the grant, renewal, or continuance of a tenancy of any premises, claim, demand, or receive any sum as premium, or claim, demand, or receive any consideration whatsoever in cash or kind in addition to rent, except for the previous controller, any sum exceeding 1 month's rent. That's all he can take. That means 200 rupees he could have taken. 2. It shall not be lawful for the tenant or any person acting on behalf of the tenant to claim or receive any payment in consideration of the relinquishment, transfer.
Yes, the agreement hit in both ways.
Agreement hits both ways. What he's trying to come and ask for is enforcement of an illegal agreement. Now, my lord, we kindly see section 23 of the Contract Act.
Yes. That is known.
It is void. It says it is void. One judgment I'll give on this. I don't think a judgment is required, but Constitution Bench judgment of the Supreme Court. Just 2 paragraphs. 2009, 10 SCC, 552. My lord will come to internal page 4. My lord, see paragraph 21. There's a CDJ citation. Paragraph paragraph boli nahi ja. My lord, see paragraph 21. He is quoting from Manalal Khaitan. My lord will see the last paragraph on that page. Paragraph number is 19. My lord has got that. Where a contract express or implied is expressly or by implication forbidden by statute, no court will lend its assistance to give it effect. A contract is void if prohibited by a statute under a penalty, even without express declaration that the contract is void, because such penalty imposes a prohibition. My lord, something very important. My lord, there's a specific penalty in the Premises Tenancy Act which says that he'll be penalized. The distinction is sometimes made between contracts entered into with the object of committing an illegal act and contracts expressly impliedly prohibited by statute. The distinction is such that in the former class, one is to look at and see what acts the statute prohibits. It does not matter whether or not it prohibits a contract. If a contract is made to do a prohibited act, that contract will be unenforceable. In the latter class, one is to consider not only what the statute prohibits, but what contracts it prohibits. One is not concerned at all with the intention of the parties. The parties enter into a prohibited contract, that contract is unenforceable. 20. It is well established that a contract which involves in its fulfillment the doing of an act prohibited by statute is void. The legal maxim, a pactis privoratarum publico juri non derogatur, means that private agreements cannot alter the general law. Where a contract expressed or by impliedly is expressly or by implication forbidden by statute, no court can lend its assistance to give it effect. If anything is against the law, though it is not prohibited in the statute only, but a penalty is annexed, the agreement is void. In every case where the statute inflicts a penalty for doing an act, though the act be not prohibited, yet the thing is unlawful because it is not intended that the statute would inflict a penalty for a lawful act. Penalties are imposed by statute for 2 distinct purposes: for the protection of the public against fraud, or for some other object of public policy.
Yes, I'll go through it.
My lord, as far as the penalty is concerned, my lord will take see paragraph, I think section 30.
Number of paragraphs are there to be looked into.
My lord, section 30, I think. There's a penal clause in the act. My lord, kindly give it. My lord, in these circumstances, I would submit that the question of merger has no role to play, number one. And my lord, if I specifically go by his notes itself,
Section 30. That is prohibitory and penalty clause.
yes, ma'am. But it says penalty of section 14. 50,000 rupees fine. So there is a penal clause. No penal clause. If I was very surprised that they come up to this court asking for enforcement of an application of a agreement, which is not only been executed in teeth of the orders passed by this court, but patently on the face of it illegal.
You come next to with the notes of argument, short notes of argument, annex it. You take it back today. You annex it with the notes of argument. How long would you take?
Gives me a week.
After vacation?
The end of this week, I will not be in town. My lord keeps it before vacation. I will not take that.
19th.
Very well.
Heard in part, adjourned to 19th May.
Yeah.
The learned counsel for the intervener is given liberty to take, applicant is given liberty to take back the first note of argument. Come on the next bit. Let me hear it. Because this must be in the notes of argument.
This, my lord, as a whole, my lord, it has been, my lord. But whether your lordship can go into the agreement at this moment or not, that your lordship will decide.
He has to first show his locus.
No.
All right.
My lord, this
Come on the next bit. Finish it. Let the argument be finished.
11 and 12.
There are two applications. One is GA5, extension of time seeking filing of written statement, and another is the application filed by my learned friend, where they have not used the reply. Professional charges have once.
Is it commercial dispute?
Regular division. Insofar as this matter is concerned, we are not standing in the way, it may be allowed. As far as their filing of written statement is concerned.
Ready written statement?
Will it be an order of court,
Where is the written statement application?
Application GA5, my lord.
I'm led by Ms.
GA5 is the defendant's application.
GA file is infructuous now. Once it is filed,
It's not yet.
Your lordship allowed GA5, giving them extension to file.
allowed. Now written statement is being filed. So GA5 no longer should be there.
Yes, your lordship has to extend the time. For
There is no extension required. Further extension is not needed.
Extensions, but because they are out of time,
Written statement filed by Ms. Agarwal, the learned counsel for defendant number, only sole defendant be kept in record. GA5 of 24 stands disposed of accordingly. Affidavit in reply in respect of GA5.
GA5 in this we have.
Affidavit in reply filed in respect of GA5 be kept in record.
or discovery and inspection, so that we can come back.
Is it a tenancy agreement?
Yes, it's a 106 notice.
They have
106 notice, but
they
this
have
is for commercial purpose.
That issue is now pending before the larger bench. So,
they have to, Lord, it has to be decided whether my tenancy is governed by the TP Act or by the West Bengal Premises Tenancy Act.
But I was humbly beseeching, subject
Question of fact.
I was humbly beseeching, subject to what falls from the lordship, that if the lordship kindly directs us to cross discovery and inspection, and we can take after the
Since written statement is filed today, discoveries, inspection, admission and denial of document as well as disclosure of document shall be complete on or before the returnable date. This suit will appear in the list on 18 June.
Kindly give a slightly longer date because discovery, inspection, everything.
Come on that date. It's longer enough. Long enough.
Yes, item number 6, my lord.
If it is not finished, then I will extend the time.
Item number 6, my lord, is the plaintiff's application.
Item number?
Item number 12. Item number 12. GA6 is the plaintiff's application on the basis of a Supreme Court judgment that which has recently come out, directing an order from this honorable court to direct the defendant to pay the market rate. Till such time, the suit
Okay, AO is filed.
AO is filed. We are not yet filed the affidavit in reply. Kindly keeps it next week, any day.
Affidavit in reply in GA6 of
24.
GA6 of
2024.
2024 shall be filed within 1 week. GA6 of come on that date. GA6 of 24
It's a different matter. It's an application. So
after vacation, at least after vacation. Will appear in the list on 10 June.
There till the 11th, between the 12th
12 June.
date.
Item 13 and 14.
Why these are appearing in my list? These are not supposed to be here.
Portion of my loan. That's the
Who is the other side? Have you served it?
Yes, we have made, sir. We have stopped it on the last occasion.
Which part you are referring to?
On the order dated 26th of March 2025, the Lordship has been pleased to direct the receiver to furnish a report as to whether there was a compliance of the order dated 7th February 1994 or not in respect to the receiver is here. Give a copy.
So what recall you are praying for?
For partition. In 1994.
Where is the recall application?
That's one.
Which part you are praying for recall?
There was a direction by my lord that the receiver will execute a register a sale conveyance in favor of the heirs of the defendant number 20. We are seeking recall of only that portion of law.
Why?
1. 1994, there was an order for sale of this property, property in favor of the defendant number 20. It was provided in that sale order that the defendant number 24 will pay the earnest money within a certain period of time and the balance consideration amount within another time. The defendant 24 deposited the earnest money of 44,000.
So I have noticed one defendant number 24.
Twice we have served.
Where the defendant number 24 resides.
Now, well, just 24 has expired, the years have been substituted. In that substitution order, they made a statement that my father has made payment of the entire consideration money, so the conveyance has not been executed, only direct the receiver to execute the conveyance. My lord, relying upon their statement, has passed a direction on the receiver. The subsequent transpired that 1994, they did not deposit the money. The order default clause applied. Order was recalled. That order, my lord. Let's see the last one. That's why we thought for recall of the order. Because they are,
what are the proofs?
The receiver has given a statement today.
This is a question of fact cannot be decided at this stage. Let this suit be disposed of and then it will be decided.
Receiver says, kindly take the receiver's report. Yes, your lordship will kindly take up. Kindly take up the application 153.
One.
The parent order. Kindly take up the parent order one first, my lord. That's 123. As far as the property at Rakhallam, Shunukar and Bihar is concerned, the same consists of one building such and such, about measuring about 18 bighas. Mr. P.S. was parties to the two. Of the interest price offered by only one of the Mr. Basu at rupees 220, rupees 2,20,500. Yes, 500. So, Bhushan is trying to being the major share of the property and is trying to purchase the property. The same is confirmed in Mr. Bhushan's line at 1,20,500 in respect of the entire property. The joint receivers will execute the conveyance in favor of
The client within 4 weeks from the date of Mr. Bush's client making payment of the share of the other co-sharers in the amount of 2,20,500. So this client will make the payment within 1 week from the date of communication of this order. This pay. Now, the motion in default of Mr. Bush's client making payment of the balance amount being the share of the other portions of the property to the joint receiver within the time specified to order confirming the sale of the property in will stand record and the sale will be confirmed in favor of
Which part you are referring to?
this part. The deposit part, when the deposit is to be made, and the middle part.
Sale will be confirmed in favor of Mahindra Basu.
That's the second part. Kindly come to the first part when the this party has to make the payment. So Ghosh's client, which I'm referring, will make such payment within 1 week from the date of communication of this order.
Mr. Ghosh's client will make payment within 1 week.
1 week from that. In default, order will stand, sale order will stand recall. Madam, got it? That's
Yes.
2 lines, only 2 lines.
Now, what is the order passed?
Now this order was passed in 1994. He was
Yes.
supposed to make payment. He made payment of only 44,000. Thereafter, the balance sum he did not make. Now, he expired in 2020. This defendant
Report says 43,090 was paid.
yes, that's the amount. That's the amount he was paid. Balance sum was not paid, so the order stood recalled. Now he expired in 2020. This is defendant number 24. Now kindly come to page 59. That's the application for substitution. Kindly come to para 7. On 7 December 2020, student defendant number 25 died due to COVID. Interested in such and such. Now come to the most important paragraph. What is the statement in para number 11, page 75? What is it is further stated and submitted that this is defendant number 24 during his lifetime offered to purchase a property as a major portion belonging to the RT estate by the name of Rakhal Dham at Chimutala, India, which consists of one building such and such at 2,20,500. Ultimately, the sale was confirmed by Honorable Justice Kumar by order till 7 February 1994 in favor of
These all are question of fact that cannot be decided in this manner by recalling petition.
that order says although the sale consideration was put paid and deposited by the
That is to be decided. That was to be decided on evidence only.
there's a report of the receiver that he did not deposit. That's why the
Conflicting orders are there, conflicting reports are there, because when the order was passed, that was one thing. The report says only 43,000 was paid.
yes, he did not make payment.
But previously, when the order was passed, where is that order?
Which order, my lord?
You are calling, praying for recall?
Recall, my lord, order.
The original order which was to be recalled.
That order, I'm thinking a recall of the order dated
19th February.
23rd, 2020.
Twenty-third June.
2020. Asking GA number 141 of 2022. That's why on the last day when your lordship heard the matter, your lordship was pleased to call for the records of 141 of 2020. Probably that file has not appeared because the GA number has wrongly gone down in my conception. That's 151.
No, that is not here. GA 141.
Yes, 141. Your lordship will kindly take up last order. Last day, your lordship ordered for the production of that records.
Record of GA 141 of 2022 be placed before this court for effective hearing.
And the report of the receiver be kept.
Record means everything. Let the matter appear in the list on 16 June.
Also take note that the receiver has filed a report.
Report of the learned receiver is filed today. Let the same be kept in record. Receiver dated
Order date, report is dated 24th of April 2025.
24/4/2025 be kept in record. Copy, have you served copy? Serve copy may be served.
Item 15.
So in this matter, if you have a defendant number 5, A, B, C, and D, and he takes up the last order, there was an order for amendment, passing 2022, substituting my predecessor and amending in my name. That has not been done by the plaintiff as of yet.
None appears for the plaintiff. Department was directed to carry out the amendments. কোথায় এটা কোথায়? প্লেনটা কোথায়? Yes, carried out.
An amended copy has not been served on me.
Amendments are carried on, have been carried on by the department. Plaintiff shall give a copy of amended plan to the defendant.
5 A, B, C.
Defendants.
5A, 5B, 5C, and 5D. I appeal for only 4 defendants.
But substituted defendant number 5A2.
A2D.
A2D.
5A2.
Positively honor before the returnable date. Let the suit appear in the list on 13 June.
Item 16. Santanu Sen.
8, 9, 10, and 11.
Dependent number.
Lord, pursuant to your lordship's direction, my lord, we've complied.
What the GAs?
Lord, G1 was filed by the defendant number 2 for extension of time.
That is.
Lord,
It was for extension
extension of time to file the written statement, my lord, perhaps.
Written statement was filed.
Yes.
Lord, we filed a written statement on
Ours
time.
is also 5.
Discoveries and inspection
Yes, my
to
lord.
be done. It is not done.
It's done, my lord. We've requested them to take inspection of our documents, my lord. They have not responded.
We have not yet received any.
Discoveries and inspections of document are yet to be complete.
The plaintiff has not taken steps, my lord. We've written to them.
Both the parties shall take necessary steps, particularly the plaintiff, to finish the job. The suit will appear in the list on 19 June.
19 June, my lord. Grateful.
Mr. Ghosh, you are running away.
No, my lord. No, in fact, yes, I found out yesterday, my lord.
17.
There's some miscommunication, but I spoke with them.
No issue. Don't say anything to the junior.
Okay.
Don't say anything.
Great.
17.
Lordship, the matter may be kept after the vacation because my advocate on records office is in 6 Temple Chambers. my
Oh,
lord.
okay, okay. Where is Mr. Mitro?
My lord,
Let me see the last order. Written statement was filed.
Thereafter, my lord, discovery inspection, that part is pending.
None appears for the defendant. Time is extended till the returnable day for discovery, inspection, disclosure of documents, as well as admission and denial of documents. The suit will appear in the list under heading for framing of issues on 23rd June.
Deeply obliged, your lordship.
18. Item number 18.
Mr. Rajchodri, I think it should be commercial.
No, my lord, my lord, lordship, kindly see the last order, my lord, 21st of March 2025.
18, item 18.
19, my lord,
No,
19.
no. 18. None appears. Adjourn to 10th June. Yes.
My lord,
19.
Madam, I'm for the defendant, my lord. On the last occasion, if you lordship kindly see the order, my lord directed the plaintiff to take the discovery and complete the procedure of discovery and inspection, my lord. But no steps has been taken. When this is the, I believe
The learned counsel for the defendant.
may the chance be closed because it cannot.
No, chance cannot be closed. Certain other harsh orders are to be passed. So let the last peremptory order be given. The learned counsel for the defendant submitted. The plaintiff has yet to disclose documents and allow inspection. Have you allowed inspection? Yes. Have you allowed discoveries inspections? The learned counsel, কি বললাম? The learned counsel for the defendant submitted that plaintiff has not disclosed document or allowed inspections as yet. The learned counsel for the plaintiff seeks for an accommodation. Plaintiff shall allow discovery and inspection of documents within 2 weeks.
And may his presence be treated as intimation, due intimation, because their office was closed when we had gone to give the letter.
No, I have noted learned counsel plaintiff submitted.
May that be.
The suit will appear in the list
Yes,
under
sir.
heading
After
framing of
vacation.
issues on 16 June.
Deeply obliged, ma'am.
Your suit will be dismissed in case it is not done. See the provision of CPC.
Item 20.
I have their Yamaha input. We had written federal committee, but they are yet to receive any such something. But we are unable to.
The learned counsel for the plaintiff submitted that you are Shobik.
Is my senior.
Okay. Mr. Niket Oja, the learned counsel appearing for the plaintiff submitted that there is no communication or instruction from the plaintiff. Let this suit appear in the list on 17 June. The learned registrar original side shall communicate a copy of this order to the plaintiff for taking necessary steps and be present on this court on the returnable day. The suit will appear in the list on 19 June.
17. For judgment, item number 2.
Granted. Not now. Some corrections are yet to be made. Although I'm signing it, a final correction is to be carried out. You will get it in the website in the afternoon.
For arguments, item number 21 and 22.
Any progress?
Lordship directed the one respondent please for.
My instruction is, although I had filed my wakalat on her behalf, communication is no longer there, practically speaking. We are also not being able to serve upon her. You
are
for that particular. I'm for the plaintiff in the application suit for partition. That's my partition. In partitions, I'm for the plaintiffs. In the probate matter, I'm for the defendant.
Same, all the.
But now, my lord, now that one party is not communicating with us. Second plaintiff is not communicating with us as well. We have requested her twice, in fact, thrice, not even receiving our communications.
As far as my lord, we are concerned, I'm the brother, they are my sister. And he has spoken to her. He has said that if everybody else is agreeable, I am also. I said that your lordship would direct let her come to court and say that, because it's strange that their own advocates are not. She's not telling them.
In terms of order dated 21st April.
Now, what she suggests, my lord, is what my lord.
Let her name be recorded in the order. Let her name be recorded in the order.
Defendant number 2.
Yes. No, that was there is a defendant number. I'm saying if a name is recorded, directly the name, and then she's asked to come, she has to come. The name Kumkum Bishas, if that is recorded and then she's asked to come, then I don't think she can avoid it.
My learning friends are appearing for her.
Yes, I am telling, but I am not being able to serve upon her. That's the problem. There is no
In terms of, although order was passed on 21st April 2025, fresh করে লিখুন. Although order was passed on 21st April 2025, giving liberty to the defendant number 1, defendant number 2, namely, এটা দেখি.
That is defendant number, it should be defendant number 3, not 2. That was the probably a
Defendant number 2 was directed to appear.
But 2 is already with appearing. This is problem is with defendant number 3, Kumkum Bishas.
Name should be.
আচ্ছা fresh করে লিখুন তো তাদের. Here it was written defendant number 2.
That's what was submitted. In the plaintiff.
It should be 3.
No, plaintiff.
In the probate testamentary suit, she is number 3. In the plaintiff, she is the plaintiff number 2.
Defendant number 3 in the probate proceeding.
Testamentary.
Kumkum Bishas.
He has gone up out there.
But I'm being
fresh করে লিখুন.
Oh.
Timothy Kumkum Bishas, defendant number 3 in CS number 90 of 2008. May be present in the court on the.
My lord, she is plaintiff number 2 in that CS, and in the TS she is respondent number or defendant number 3 in the testamentary.
Plaintiff number 3 in CS.
Plaintiff number 2 in the CS and defendant number 3 in the TS.
Plaintiff number 3, it is written as contractual plaintiff number 3. 2 is substituted by 2A. Then, yes, see the cost title. Mr. Dotto, please check the cost title, see.
The partition suit.
Yes.
Plaintiff.
Plaintiff number 3.
Plaintiff number 3 in the partition and administration suit and would be caveatrix, but defendant number
1. Yes. Give it to in the 1.
It was noted in the order dated 21st April 2025 that talks of settlement are in progress. It was expected that parties may settle their disputes amicably. The learned counsels for the party submitted that the plaintiff number 3 in CS 90 of 2008, Srimati Kumkum Bishwas, may appear before this court to express her views on the proposed settlement. A copy of this order may be sent to Srimati Kumkum Bishwas.
Okay, key.
Now, line take care din. Srimati Kumkum Bishwas may be present in the court on the returnable day to express her views. A copy of this order may be sent to her by the learned registrar original site. Enabling her to be informed of. No, দরকার নেই.
One thing, your lordship has recorded up to this point. My client has said that he has spoken to her on the phone. He is agreeable if others are agreeable. And her daughter has just now called his sister and sent him outside. He is aware of today's proceeding. And of course, they want to say something, that's fine. Whatever they want to say, the clients are here. But he knows about today's thing. She will, if she comes, then everybody will benefit. Otherwise, this is going to go on.
Copy of this order may be sent to the learned registrar, sent by the learned registrar original site to the site Srimati Kumkum Bishwas.
We have a phone number.
For her knowledge.
Let the registrar be informed.
Let this be done. Let the matter appear, let both the suits appear in the list on 19th June for further hearing with liberty to mention. 19th June is okay? With liberty to mention.
Yes, let us express a view. Otherwise, argument anytime, your lordship. Let it be next week.
Only for the purpose, only for the
brothers have all come.
20th May, make it 20th May. Because registrar original site must communicate it.
Then you should give the phone number.
Not phone number, let this.
It can be recorded. Otherwise, there's no way they don't have the address. They are representing her.
Let them communicate the order.
We are communicating.
saying that we don't.
You provide the phone number.
Yes, the phone number.
The learned counsels may also provide phone number.
Liken in order. 9678
PC.
96748 725450. What's it? Licklen, put it in. 667.
The learned registrar original site may also communicate her over the phone. 20th May, with liberty to mention.
We are obliged to your lordship. You are obliged to your lordship, my lord. By way, this way it can be settled.
If settled.
'23 and '24.
I was hearing whom?
Yes, hearing that. Mr. Shah is leading me. He's on his way. I can start.
Yes.
This is that. There are two suits your lordship recollects. Item number 23 is their suit for damages of about 5 crores and odd, and item number 24 is my suit for recovery of earnest money paid in advance of 1 crore and odd. The subject agreement was one for transfer of shares in a company. The agreement provided for a total consideration of 28 crores.
Yes, that I remember.
Lordship recollects. There was also a provision for payment of an earnest of about 50 lakhs. Not only did we pay the 50 lakhs, we paid more than that. About 1 crore was paid, undisputed. Your lordship was shown the pleadings in their plaint as well as in the written statement filed by them in our plaint. In both the pleadings, they have unequivocally admitted that this 1 crore was received by them. Now, so far as my suit for recovery of 1 crore is concerned, there is no dispute with regard to the factum of payment. They join issue by saying that this 1 crore has been forfeited by them to set off against the loss that they have suffered. What is the nature of the loss? They say that according to the agreement between us, the consideration was 28 crores. Because I did not follow through with the agreement, I terminated the agreement. They were constrained to enter into a further agreement for sale of the self-same shares to a third party, and they did so at a lesser price. This was a distress sale. Now, their counterclaim is based entirely on this loss. That 28 crores and 22.5 crores, which is the sale price received by them from the third party, the difference they are claiming from me, which is about 5.5 crores. Apropos that, they set off this 1 crore that we have paid, saying that this I have forfeited. So the question, essentially boils down to this. Number one, whether they are entitled to forfeiture of this earnest money of 1 crore that I had paid, whether the terms of the agreement contemplates any liquidated damages to be invoked by them so as to forfeit. And number two is their claim for damages, to which I say that there is no evidence. Now, it is one thing to plead that I have suffered a loss, but they have to come up with cogent evidence to prove that loss. Merely saying that a loss is not good enough. Now, what is the evidence your lordship will see that they have come forward with? They have only come forward with one document, which is an agreement, unstamped, incomplete, schedules to the document are missing, and it is not even signed. It has all come out in course of cross-examination. What are the other documents that they could have tendered to substantiate this loss? In my respectful submission, two documents. One is that these shares have actually been transferred, that they have stood transferred to this third party. This is a company. Now, share transfer scripts are to be executed, they are to be filed. It is to be recorded with the registrar of companies that these shares stand transferred to such and such person. Not done. No evidence, and I had also, subsequently, your lordship might recollect, I had come forward with an application to disclose these documents. The list of shareholders of this company for the financial years, these agreements are of 2011. I came with the list of shareholders for 2012, 2013, till the company went into liquidation after 2013, showing that the list of shareholders still reflected their names as shareholders of the company. So, the shares are not stood transferred to any third party. And the other document that they could have come forward with was bank statements to show transfer of funds, that they have actually received 22 crores, and therefore there is a loss that has been suffered by them of 5 crores. Also not tendered in evidence. So the only document that they are with is that agreement. And I will show from the evidence also this purported story of this agreement perhaps does not hold water. Your lordship will see from the chronology of events what transpired after the agreement. Agreement is of September 2010, 20th September 2010, 24th September 2010, within 4 days, by SMS message we terminate, not in dispute. They accept the termination. They do not file any suit for specific performance of this agreement. They wait till about March 2011 to forward a letter to me said to have been issued by their banker under SARFAESI, a 13-2 notice saying that, look, bank has taken steps. In the suit, they say that already in February 2011, they had entered into an agreement and sold these shares. Your Lordship will see the nature of circumstances is so suspicious. If it is really the case that in February 2011, these shares stood transferred to a third party, they had already parted with these shares. They had nothing to do in the company anymore. They are not shareholders. But for what purpose, if I may ask myself this question, was this March 2011 correspondence issue saying that bank has initiated SARFAESI proceedings? Admittedly, the agreement stood terminated in September 2010. They do not dispute this termination. They do not file any proceedings for specific performance. They wait till February, allegedly enter into an agreement with third parties, sell off these shares for a lesser price. In March, they write to me saying that bank has initiated SARFAESI. Then they file this suit saying that you pay me the difference in the price. The only documents which could have been tendered in evidence to establish this alleged loss having been suffered, not tendered in evidence. All that they come forward with is an inchoate, incomplete document styled as an agreement. Now, if you're
according to you, this is not a distress sale.
Well, they have not even been able to demonstrate that there has been any sale. There is no evidence before the court today that they have sold it to these third parties. There is no evidence. If your Lordship allows me to, Mr. Shah.
As your Lordship may have guessed by now, the matter is really very short. Now, admittedly, there was an agreement of 20th September 2010. Agreement was for sale of shares. We say that we terminated the agreement because you proposed an amendment on the very next date. That, my lord, amendment is in dispute. Let me not go into that. But the fact is, there was an agreement for sale of shares on 20th September 2010. The fact is, as has been admitted in the plaint itself, is that I had terminated this agreement on the 24th of September 2010. Well, that is also a fact. This is also acknowledged in the plaint itself. Now, but my termination may be right, my termination may be wrong. Now, today, if I have agreed to purchase shares for you at a particular consideration, but in that case, the next thing to do would be to sue me for specific performance. You had agreed to purchase these shares, you have made a payment of ₹1 crore, you better purchase these shares. Well, that is not this. So, what does this mean? In the law of contracts, we say that this is acceptance of repudiation. Now, today, contemporaneously, if I terminate an agreement, let us say wrongly, in that case, you have twofold remedies. One is to sue for specific performance, other is to sue for damages. Now, so far as specific performance is concerned, no suit. Not even a demand that you must specifically perform this agreement. Not one solitary correspondence. So, the termination is accepted. Now, claim for damage. When did they make the claim for damage? As your Lordship has been told, the claim for damage is made for the first time in March 2011. That is not also a claim for damage. It is only an intimation that SARFAESI proceedings have been commenced against me by the bank. And they say the damage that has been caused to them is because they were forced to sell their shares at a lower value to a third party. Now, the first stage, legally. If today I terminate an agreement, what is your obligation? Your obligation is to ask me to perform the agreement because you say that the termination is wrongful. Now, your Lordship will look in vain for any correspondence to this effect. That I don't accept your termination is wrongful, please perform the agreement. Now, if today the termination is accepted, if the repudiation is accepted, so one situation, scenario number one, I don't accept the termination, I don't accept the repudiation. Well, if I don't accept the repudiation, then scenario two is you specifically perform the agreement. The third circumstance is, yes, I accept the repudiation. But I hold you responsible for loss and damage that I will suffer. Well, that has to ultimately also be followed up by an intimation to that effect. Well, that is also not done. Now, today the question therefore is, when do they first assert their right to say that, no, I don't accept the termination of the agreement, or I accept it to be a wrongful termination, hence I will claim damage. Now, as your Lordship will find from their plaint is a plaint for damages, not a plaint for specific performance. So without seeking specific performance even once, without calling upon me to perform the agreement even once, they ultimately say that no, so far as this agreement is concerned, you will have to compensate me by way of loss and damage. When does that claim for compensation come? After, my lord, I call upon them to refund that 1 crore of rupees which I had paid them. Before that, there is no claim for compensation at all. That I should show your lordship from the sequence or series of events. So, my lord, here your lordship has a scenario where, my lord, repudiation of the agreement is accepted, no demand for performance, no claim for compensation or damages, claim for compensation of damage made for the first time. After, my lord, I serve on them a notice saying that please refund my 1 crore of rupees. Well, that is the scenario. Now, my lord, the second thing is, my lord, what is their case? Their case is I had to sell the shares to a third party. Now, as my learned junior has pointed out to your lordship, my lord, in March, they write to me, say that, look, bank is starting SARFAESI proceedings against me. Now, in all those correspondence, there is no mention of any agreement with a third party. Now, my lord, today, if they are going to sell their shares and transfer their liabilities, then the bank's liability is going to be taken over because that was my agreement. In that case, my lord, they are not concerned as to whether the bank is, my lord, ultimately issuing SARFAESI action or taking SARFAESI action or issuing SARFAESI notices against the company. That is not their lookout. But, my lord, as your lordship has been told, they say SARFAESI without mentioning, my lord, that there is, my lord, already a sale of the shares in favor of a third party in February 2012. Now, my lord, next thing, assuming that there is, my lord, in fact, a sale. I am giving your lordship the perspective of the matter. Assuming for the sake of argument, they have in fact sold the shares. But the sale of shares has to accompany, under the Companies Act, a particular process. My lord, you have to, my lord, in the case of, my lord, share certificates, in case the shares are not dematerialized. In that case, my lord, the law is, my lord, now laid down by the Supreme Court in 81 Supreme Court, hand over the share certificates, execute the transfer deeds. On the basis of the transfer deeds, my lord, they are lodged with the company.
Rectification of register of shareholders.
I'm grateful. Well, that is what has to happen. Now, well, has your lordship been told that this has been done?
101 or 110 possibly.
101. And well, Mannalal Khaitan, 81 Supreme Court is, my lord, the leading case on the subject.
And its courts.
Yes. Now, well, that has not been done. There is no assertion, there is no averment. So, my lord, if to say that I have sold the shares, it must reflect in the books of the company that shares have in fact been sold. Your lordship will find that no document has been disclosed. No document to show that sale of shares in fact took place has been disclosed. Next thing, my lord, they say shares have been sold for a consideration. About 22 odd crores, for which they say I've suffered a loss of around 6 crores of rupees. Well, there's no proof of receipt of that consideration. Now, my lord, since we have ultimately come down to, my lord, only one question, that is, my lord, ultimately, did you sell the shares? Did you suffer a loss? Now, my lord, there is another question that will, my lord, ultimately precede this question, and that question will be that if you have accepted the repudiation without any consequence, and if sold the shares without any notice to me, if you have sold the shares without telling me, look, if you do not buy, I will sell it to a third person and sue you for the loss that I suffered as a consequence.
That caveat was not there.
Not there. And, my lord, your lordship is familiar with the concept of risk purchase. My lord, this is a risk and cost sale. That if you do not buy, I will sell to a third person, and if I suffer a loss in the course of such sale, you must compensate me. No such intimation, no such caveat. Now, my lord, here, if your lordship now, my lord, please have a look at, my lord, this particular agreement on which my learned friends rely. My lord, this agreement is the agreement on which my learned friends ultimately found their entire case.
Is there any compilation?
Well, there's a judge's brief. There is a judge's brief, my lord, for both, my lord, my suit and their suit. Now, if your lordship sees the judge's brief in, my lord, suit number CS 264.
This is CS 264.
CS 264 ওদের agreement আছে তো? Or CS 124 এর? I'm sorry, my lord. It's judge's brief in CS 124, your lordship. 124. Now, my lord, please see. My lord, this is the judge's brief prepared in their suit, CS 124. If your lordship will kindly have a look
MOU.
at it.
Is it MOU?
Yes, my lord, MOU, 10th February 2011.
Yes.
Now, my lord, if your lordship will please have a look at, my lord, this MOU once. And my lord, straight away come to, my lord, page 27. My lord, the page number at the top right-hand corner. Internal page of the MOU is not there.
Which clause you are referring to?
My lord, kindly see, my lord, just before the, my lord, the last recital, before now this indenture witnesses. It's not an indenture in any case.
And whereas transferor and transferee.
Well, just before that, the transferors having made a proposal to the transferees.
Yes.
Yes. Well, may I just read this? The transferors having made a proposal to the transferees to sell and transfer the shares, assets, and properties, including lands held by the landowners in their respective names, but leased to the company at or for a consideration of 22 crores. Well, transferees agreed to the said proposal. Now, my lord, please see. My lord, what this says in paragraph 2 under my lord, this indenture witnesses. It is made clear that the transferees herein are only taking the liability of Bhumi Minerals Limited to the extent of its bank liability payable to the Indian Overseas Bank, Dhanbad branch, and all other existing liabilities, including tax liabilities, statutory liabilities, shall be paid and borne by the existing directors such and such, who further indemnify the transferees towards the same, and against all suits, claims, etc. So, my lord, what they say is that, my lord, the liability of the Indian Overseas Bank is going to be taken over. What is the extent of that liability is not spelled out. And all other liabilities will remain the liabilities of the owners. Now, my lord, in this context, please also, my lord, please now consider the correspondence that has been addressed. Well, if your lordship will please see, now, my lord, now the, my lord, letter which is at, my lord, page 12 of the judge's brief in 264. We take to 264 judge's brief.
Can we prepare a convenient compilation?
Well, together with the two suits, well, what I would have ideally done is, my lord, combine the documents. Since your lordship is hearing the two suits analogously, chronologically, my lord, all the documents.
Right.
Well, that is what.
With exhibit numbers.
That is what should be done. If your lordship will find that
Because I have to switch over from this one to the.
Don't do that, my lord. Let me, kindly give me an opportunity. Let me, my lord, prepare that document. It will not take much time. I shall come back.
Judge's brief are not very heavy.
No, very, very short. But, my lord, it will be convenient for your lordship to have everything.
With exhibit numbers.
Yes, with exhibit numbers.
Heard Mr. Shah, the learned senior counsel in part. A convenient compilation of documents and exhibits may be filed.
Well, in both suits. In both suits may be filed.
In both suits. A single convenient compilation of documents adduced in evidence in both the suits may be filed on or before the returnable date. After vacation?
Yes.
The suit will appear in the list for further argument on 12th June.
Yes.
12th June.
Let a copy of this compilation be also served on.
Yes, ma'am. I'll give you. It need not be an order.
Mr. Mukherjee was arguing.
Yes, but he's stuck today. My learned friends are there. I can continue. Otherwise, I was suggesting, your lordship, on the reopening, your lordship keeps it for 3 days. If Mr. Mukherjee is there, it's fine. Otherwise, I'll finish the argument because it's already got. Only
I've
2
heard it
days has been
substantial.
heard. Twice, but then your lordship is on the first judgment only. So there are several judgments. My lord keeps it on the whichever week. The second week is beginning 10th.
As per your lordship's convenience, anytime after the second week.
Or I can continue for some time today. That's not a problem.
No, it will take time. Today there's a resolution.
No, but I want your lordship 2-3 days just because the basic point your lordship has got. I just need to substantiate
Second week.
a few judgments.
As per your lordship's convenience, second, third, fourth, whichever you want.
Perhaps third week, my lord.
That is 16th week.
Mr.
Heard in part, adjourned to the matter with the hearing will appear in the list consecutively on 16th, 17th, and 18th June. Check it.
Yes. My lord, 17, 18th, and 19th, because 16th I'm tied down. I'm appearing for the intervener number 3.
17th, 18th, and 19th.
17, 18, 19.
My lord, so far I'm good on the 17th, because 17th I'm there before this honorable court. I'll be there before this honorable.
18, 19.
17th, 18th, 19th. That's what my learned friend is.
3 consecutive dates, 17, 18, 19.
My lord, just give me a minute.
We will take those 3 days.
My lord, 18th I'm before this Honorable Bombay High Court in an arbitration matter. So 18th I'm not the 17th and 19th. 19th I'm fine to appear before this honorable court.
23, 24, 25.
So then it's get very. No, what is it?
So 23 and 24. My
Yes,
lords, because the diaries 20. Let's keep it for 2 days. Then my lords, we will
17th and 19th.
17th and 19th.
Yeah, 17th and 19th is fine. Or 23 and 24 if my learned
That
friend.
will decide later on. Let
Yes,
it
my
be first. 17th, the suit will be heard consecutively on 17th. The application will be heard consecutively on 17th June and 19th June.
Oblige, my lords.
Would it be at 2 p.m.?
2 p.m. Of course, 2 p.m.
My lords, they have to still serve that compilation on me, which they have tendered. There are order directions of this
Compilation should be
which we have
given.
not got the compilation of the judgments. So that we are on add item with the honorable court also, because we have got
Compilation of judgment may be given.
We
Written
have
notes of
given
argument.
the first compilation. The others are just reported judgments. And we've given the list of judgments. We haven't photocopied the judgments. That my learned friend
At
can
least
get
get the list.
online. Or we can send it to you online, I suppose.
Fair enough, my lords.
Mr. Kalyaniwala.
That's right.
List deva ache tomar. We'll send it.
Oblige, my lords. 17th and 19th. Oblige, my lords.
Yes.
Witness action, item number 26.
My lord, in this matter, I am for the petitioner, my lord.
Where is
My
the
lord,
witness?
Witness is not come, my lord, 69 years old, my lord, very old, my lord. This is the doctor's certificate, my lord. Your lordship adjourns sometime, my lord, because he is not able to, my lord, last occasion I submit, my lord.
Should I appoint some commissioner?
For file an application, your lordship directed. But that application was he is not able to come and sign, my lord, before the.
So after vacation?
After vacation, my lord.
On prayer of the learned counsel for the plaintiff petitioner, hearing is witness action is adjourned to 16th June.
Deep down.
27.
Whatever witness action has concluded, madam.
Concluded.
Yes.
देखिए witness action किया है.
Both executor and attesting witness both are
Attesting witness, both are there.
both are examined. Concluded.
Today is fixed for argument. Let me see. আরে এইটা দেখে কি হবে, আমাকে ইয়েটা দাও না, সাক্ষীটা দাও না। Only one witness.
One witness, only one witness. There are two, but came to the court while another person has not come. Is reluctant to come. Only Papri Sengupta has come.
Tamugno Guhanyogi was the executor. He is the executor. Death certificate was marked.
Original death certificate produced.
You did not put any question. What was the physical and mental capacity? দিয়ে দাও, order করে দেবো। I will pass order.
28. Item 28.
Item number 28 and 32 are matters, my lord, fixed for witness action, but the plaintiff is the same, my lord. The recovery of money suit against the defendants, my lord. Now the witness is not in a is
Prayer of
indisposed
the
to.
learned counsel for the plaintiff.
Now, my lord, in a similar matter, there is another suit pending where your lordship has directed that there has to be a hearing on the issue whether these suits are falling under commercial suits or not. It was heard by your lordship in the month of January. It was returnable in the month of February, and that matter has not been listed before your lordship. Then the name is the CS is 16196.
On prayer of the learned counsel for the plaintiff, witness action is adjourned to 11 June. These two suits will appear in the list along with CS number
CS 196 of 2018.
196 of 2018 on the same date.
Grateful, your lordship.
$29.
I'm happy with it. My witness 29. Malad, we are for the defendants. We were cross-examining the plaintiff's witness.
Yes, sir.
But Malad, we have circulated a letter that because our client is not present, lordship, because of a bereavement in his family, lordship, we have not been able to, lordship. We need some time
He was
to
being
prepare.
cross-examined.
My lord, yes,
Lordship,
He is the witness to be
my lord,
cross-examined.
my lord. The bereavement of the defendant relative is not necessary because
lordship, we need to sit with our clients, my lord, before cross-examining.
On prayer of
We
the
need-
learned counsel for the defendant. Defendant, witness action is adjourned to 16 June.
I'm grateful, my lord.
Item 30.
The testamentary matter. Your lordship.
Witness?
Yes, my witness. There are two attesting with lordship. May recall. The Sunita Agrawal was another attesting witness named in the will. Attending witness was also examined by before your lordship.
Srimati Sunita Agarwal,
But she,
a member of Bar Library Club,
he used to sit at parcel room number 50,
Bar Association, is requested to appear before the court on the returnable date. A copy of for deposing before this court as an attesting witness. A copy of this order may be communicated to her by the learned registrar original site. Let the suit appear in the list on 18 June.
The only one thing, his address in the will is also there. Can it be possible to incorporate that address also? Because she is not used.
The proper address shall be provided by the learned counsel for the petitioner to the learned registrar original site for communication.
Yes, great. But one thing I must point out before your lordship, she was there was a knee replacement of her that has been communicated by his senior.
Mr. Garg.
Yes, my Sunita Agarwal was there was a knee replacement.
She's,
So
if
she
she's
will
not
be
able to come, then another day will be
Yes,
fixed.
ma'am, on the bus, he will be available from 20th of June.
Otherwise, Mr. Garg will come here
Yes, ma'am.
and he will depose. Tell him, tell Mr. Garg.
Yes.
He will come and
He-
depose.
There was an assurance from him that he will be before your lordship today to communicate this fact before your lordship. But he's
Mr.
not.
Garg কে বলুন ওনাকে ডেকে এনে সাক্ষী করাবো।
Yes, sir. That was our request to him. Sir.
Anyway,
I am grateful.
That's a light, in a light mood.
Absolutely. Difficulties. This everybody is present. Nobody is objecting. It's because of the
Technical issues.
Technical issues. With this. Grateful.
31.
Yes, your witness is there.
My witnesses. Before the witness comes to the box, there are probably two typographical errors, if I may
Make
point.
corrections.
Probably one may require your lordship's consent. My lord. Question number 24 and 25. My lord, question number 24. He was probably asked, was he crippled at that point of time? What has gone in is he was totally bedridden at that time. Next question, how was his mind at that time? His mind was absolutely fine. After having released from directorship, he was regularly visiting his office. Probably these are contrary to each other, and probably the first answer may not have been given by him.
You do one thing, put this question once again.
Right.
জয়ন্ত গাঙ্গুলি
কোশ্চেনটা দেখাও না। That is question number 25.
24 and 25, ma'am.
See these questions and your answers, whether that was the correct answer, correctly written.
Yeah.
Question number 24 is not correctly mentioned.
Yes, what is the right answer?
Right answer, he was totally fit, physically as well as mentally.
দেখি একটু। To the court. Answer to question number 24 is wrongly typed. He was totally fit at that time. He was not bedridden at all. This answer to question number 24 may be corrected accordingly.
Question number 23 as well. It is said, why did he go to the registrar for registration? The registrar actually came to his house. It was done on commission.
Answer to 23, question number 23 should be the registrar came to his residence for registration. To the court বলে নিয়ে নেবে ওটা. It is wrongly typed.
Another thing, my lord, his age has gone as 54 plus. It should be 56 plus, my lord, at the very beginning, my lord.
That is the typographical error.
Right.
That may be corrected. Age has nothing to do with that.
That I bow down to your lordship.
Yes. Who is the defendant? You are the defendant.
I'll just put some questions in regard to the death certificate because that is the.
Don't take my permission. Ask relevant questions.
Right.
You're always shaky before me. ধার খেয়ে কি এরকম হয়েছে?
Mr. Witness, I am showing you a document pertaining to page 14 of the application. Can you identify this document, page 14? shown page 14 of the application.
Is it original?
And it is original annexed with the application.
What is this?
COVID application. Right?
What this document is about?
This is death certificate of Mr. Anil Kumar Sen. Of late Anil Kumar Sen. Anil Kumar Sen.
Is it original or copy?
It's original because the hologram is there.
The hologram is there, therefore it is original. এটা লিখে নয়? Exhibit A.
Exhibit B, my lord, subject to correction. The exhibit A is the will, my lord.
B.
Will is exhibit A.
My lord.
How it was exhibited? Someone came, witness came.
But he has only on the last occasion he has come and he has
But
exhibited.
will signatures are to be proved.
Signatures he has encircled, my lord.
Who is the attesting witness?
He is the attesting witness. He is
Because
one of the
attesting
attesting
witness.
witnesses. The only thing, my lord, it has gone in that on the first page he has encircled. He has actually encircled all the pages.
Yes, that should be done. And signatures will be collectively, signature of the testators collectively marked. Is it there?
Yes. But we'll kindly come to question 18, my lord. Question 18 back to that one.
A1, collectively A1. You are Jayanto Ganguly?
Yes, Miller.
ঠিক আছে, mark আছে proper.
These are the only two documents.
Yes, marked. Signatures are marked collectively. All signatures are marked. Anything else? ডিপোজিশনের মধ্যে থাকবে, উনি নিজেই কারেকশন করছেন, আমি তো আর বলতে পারবো না সাক্ষীটা কি হবে। যদি কোর্ট বলে ওটা দিয়ে দাও।
Question 9, it has gone in as, do you find any other signature of Anil Sen? He says on the first page. Thereafter he says, please encircle the same in blue pencil, but he has signed on all the signatures in all the pages.
These are marked, these are identified. That's all.
Deeply, that is.
Yes, cross. Ask one or two questions, then continue. Just introductory cross-examination. Opening up.
Are you aware of anyone known as Abhijit Sen?
Yes, he is the son of late Anil Kumar Sen. I read it in the will also. When Mr. Anil Kumar Sen explained, I mean, he read out the will before signature, he mentioned the name Anil Kumar, Abhijit Sen also.
How did you know Mr. Anil Kumar Sen?
Because I am still working in his organization. Previously, he was shareholder and director. After that, he transferred his share to his younger son, Mr. Surojit Sen. But I'm still working with them.
What is the organization's name?
Calcutta Seafoods Private Limited.
Calcutta Seafood.
How are you related? In what capacity are you employed in this company, namely Calcutta Seafoods Limited?
At the time of before the will,
At the
or
time of execution of the will,
Execution of
I was in accounts as an employee, and I was looking after
what was your designation?
accountant.
I was employed as accountant. I was designated as accountant at the point of time when the will was executed.
When were you first engaged as an employee of Calcutta Seafoods Limited?
I was as a casual from in 2004 December, then permanent from 1st April 2005.
In what capacity were you employed in the year 2004?
This is I was doing all that billing and initial all that. After that, I confirmed on April as an accountant.
My initial assignment was billing and doing other paperworks.
Right.
He's PW2.
PW1.
PW1 is examined in chief fully and partly cross-examined. Further cross-examination is deferred to. When will be able to come?
I'm free if whatever the date
date
suits them. The date.
20.
May.
Not possible. After vacation.
Very close to the vacation.
11 June. 11 June.
May I leave now?